Today, we're going to be going over a key document that is vital for anyone looking to purchase a home. This document is the Buyer Representation and Compensation Agreement. What's up, you guys? My name is Michelle, and I help first-time home buyers and first-time home sellers save money, and I help make the process smooth. You know, now that the NAR settlement agreement has passed, every interested buyer that's looking to purchase a home, before they go out to tour homes, they have to enter into an agreement with their realtor. There are two separate agreements. Today, we are going to be only going over the Buyer Representation and Compensation Agreement. Go ahead and subscribe to this channel because I will be following up with another video that goes into detail about the other form as well. Personally, I love this idea. This is something that I've been doing as a standard practice for my business, and I'm just so happy that everyone else is on board with this because buyers were going out into the market not knowing what services that their realtor provided for them and what the expectations were. So a lot of times us as consumers, we think my realtor should be doing this or my realtor should be doing that, not really knowing that there are some things that are out of the scope of the realtor's specialties. By the end of this video, you're going to have a super clear understanding of this agreement and why it really matters to your home buying journey. And if you guys want to get in touch with me, check out the links in the description. Okay, without further ado, let's dive in. The very first form that you're going to see is the disclosure regarding real estate agency relationship, also known as the C.A.R. Form AD. I highly recommend that you read everything in detail. What I'm going to be doing is giving you a summary of the forms, but I do recommend that you read them in detail. First, we have the seller's agent. A seller's agent works exclusively for the seller. Their primary duty is to the seller, and they owe the seller the utmost care, integrity, honesty, and loyalty. They are also obligated to disclose all facts that materially affect the value or desirability of the property to both the seller and the buyer. Buyer's agent, that would be me or your realtor. As your buyer's agent, I work exclusively for you, the buyer. My primary duty is to you, and I owe you the utmost care, integrity, honesty, and loyalty. I will diligently exercise reasonable skill and care in performing my duties and will disclose all facts known to me that materially affect the value or desirability of the property. Both realtors do not have to share any private information they learn from one party with the other party, as long as it doesn't affect their main duties of honesty, fairness, and disclosure of important facts. Let me give you some examples. Example number one, financial information. Okay, so here's the scenario. The seller of the home tells the listing agent they are in really bad financial debt. The seller's realtor doesn't have to tell the buyer or me about the seller's debt because it's private information and it doesn't affect the property's value or desirability. Example number two, buyer's job situation. So here's the scenario on the flip side. So let's say the buyer informs their realtor that they might be getting a new job, which will result in a pay raise, and they'll know in a few weeks after they purchase the home and have moved in. In that scenario, their realtor, the buyer's agent's realtor, doesn't have to inform the seller about the buyer's potential new job because it's private information that doesn't affect the buyer's ability to purchase the property. Okay, now let's go to agent representing both the buyer and the seller. In California, realtors can legally represent both the buyer and the seller in the same transaction. This is called dual agency. And just a heads up, even though it's legal to do dual agency and tons of realtors do it, I don't do it. I guess that's what makes me different in one way is I do not do dual agency. I do believe that it is a conflict of interest. Okay, so here's how dual agency works. The realtor has to go into a neutral state. The realtor has to be fair and honest with both the buyer and the seller. The realtor has to keep certain information still confidential. For example, the realtor can't tell the buyer that the seller is willing to accept a lower price or tell the seller that the buyer can pay more. Confidential information. So the agent cannot share any private information from one party to the other. Dual agency can only happen if both the buyer and the seller agree to it in writing. Everybody has to be on the same page. Everyone has to know about it. Both parties do need to understand that the agent will have a relationship with the other side as well. Now, we talked about having the same realtor represent both sides as a dual agency, but here's another caveat to that. Dual agency can also mean two different realtors representing the buyer and the seller separately, but they're with the same brokerage. The form also outlines the responsibilities for both sellers and buyers. Regardless of the agency relationship, it is crucial that you as a buyer exercise reasonable care to protect yourself. This includes reading and understanding all agreements. For example, consulting with legal or tax professionals for advice. Both you and your realtor will acknowledge the receipt and disclosure of this form by signing and dating it. This step is crucial as it ensures all parties are aware of and understand the agency relationships involved in the transaction. In summary, this disclosure form is all about transparency. It really helps understand and break down the different ways that a realtor can represent you as a buyer. Either they're working with you exclusively or dual agency. This form does not confirm it. The purchase agreement will confirm it. This serves more of an explanation. Buyer representation and broker compensation agreement, also known as the C.A.R form BRBC. Let's start with the right to represent. In this section, it specifies that the buyer grants the broker the non-exclusive or exclusive right to represent you in purchasing a property. The key here is whether you want an exclusive representation, meaning that you'll only work for me the duration of the agreement, or non-exclusive, which means you're working with me and other realtors. Just a heads up, I will only do exclusive representation. I do not do non-exclusive representation. You know, us realtors, we are independent contractors and we only get paid when we sell a home. So it's not a good business decision for a realtor to go non-exclusive, because then you don't have the security to know that that buyer is going to be loyal to you. With regards to the form that we just went over, and it explains that the realtor's duties to the buyer, and one of them is loyalty. And so that is definitely something that has to be reciprocated in my book. So I will only do an exclusive agreement, and so the loyalties are reciprocated. Next up is terms of representation. This outlines how long the contract is going to be in place with both the buyer and the broker, and it cannot exceed 3 months unless you're an LLC or a partnership. All right, and in section B, the property to be acquired, this outlines the type of property that you're looking for, or properties if you're looking for multiple units, the location, any additional descriptions. And there's also a form here that you can complete that'll give me a lot more information as far as what your preferences are. Let me bring up that form for you. Okay, here it is here. See, it has the price range, the property use, the property type, the features, minimum bathrooms, bedrooms, and all of that here. And then this right here is a section if you want to exclude any properties that you don't want to be considered during the duration of our agreement as well too. Moving to broker compensation. Okay, so this one is crucial to understand. You'll see that the broker fees are not fixed by law and they can be negotiated. If I receive compensation from the seller, that amount will reduce or entirely cover what you owe for my services. Now, here's an important part: continuation of the right to payment. If you've worked with me during the agreement and I introduce you to a property, but the transaction happens after our agreement ends, I'm still entitled to compensation for that property. This is why a clear timeline and communication are essential. Let's talk about cancellation rights. For a non-exclusive agreement, you can cancel right away. For exclusive agreements, and again, 100% of the time, these are the agreements that you'll have with me. There's a 30-day notice required before cancellation becomes effective. But even with cancellation, if you purchase a property I show you, my compensation still applies. All right, now we're getting into a very important section, the buyer financial personal information, which is labeled Section 2G. This section outlines the financial and personal details you'll need to provide as a part of the home buying process. Within 5 calendar days from the execution of this agreement, you'll have to provide, let me pull up this form here. It's the CAR form BFPI, buyer's financial and personal information. It says buyer and broker agree that it is beneficial to both if buyer identifies in writing buyer's financial condition and personal information that broker can use in assessing and identifying properties that may be satisfactory to the buyer. So this is, okay, let me continue. If buyer does not qualify to purchase the type of property for which buyer is interested, broker and buyer may mutually alter the terms of the representation agreement, or broker may cancel that agreement. What is the amount of money that's available for your deposit? What is the amount of money available for your down payment? What are your sources of down payment? Where is your down payment coming from? Your savings, retirement, gift, loan, etc. The amount of additional funds available for broker compensation and closing costs, source of additional funds, your maximum loan amount, your lender's information to here. Are you pre-qualified or are you pre-approved, or do you have a fully underwritten pre-approval? I'm going to link a video that identifies and it goes into all of these details as far as like what it is. Heads up, you never want to just be pre-qualified. That is a big red flag. It is good to kind of know, but you want to either be pre-approved or fully underwritten approval. Ask me questions about that in the comments if you want to know more about that. But again, I'm going to link another video that goes into explain that as well too. The type of financing, personal information, do you currently own or rent? This form is very, very, very important. And then your real estate experience. Are you a broker, a salesperson? Are you a contractor, an investor? Are you a tradesperson, i.e. plumber, electrician, landscaper? This form is very important. So within 5 days, you'll have to send this form back to your realtor. And this right here, G29B, other financial considerations. This is where you're going to check off the buyer does not have sufficient funds to pay the broker. Buyer intends to purchase with the following loan product, with which does not allow the buyer to pay compensation to the broker. If there's a loan out there that doesn't allow you to pay for your representation, then you would check that box here and list the name of the bank and the loan officer. Next are the advisories that are going to be attached, which is the broker compensation advisory. We're going to be getting to that next. Let's move on to Section 4, compensation to broker. This section reiterates that the real estate commissions are not fixed by law and are fully negotiable. The compensation that we agree upon will depend on the services I'm providing. And it's important to know that I have 3 packages for all of my buyer clients to choose from. This way, you're in the driver's seat and you can select the services that best fit your needs. Broker right to compensation. This section explains the conditions under which your broker or realtor is entitled to receive compensation for their services. The key points here revolve around whether your representation is non-exclusive or exclusive, and whether the broker was involved in helping you acquire the property. Non-exclusive representation, broker involvement. Okay, so non-exclusive representation means that you as the buyer can work with other brokers or realtors simultaneously during the representation period. Your broker will only be entitled to compensation if they had quote unquote broker involvement. And we're going to get into those details. With the property you end up purchasing or leasing. In this non-exclusive situation, the broker must have played a direct role in helping you secure the property to be paid. Exclusive representation, buyer acquisition. Exclusive representation means that you are agreeing to work solely with one broker, with one realtor during the representation period. If the exclusive option is checked and initialed in the agreement, the broker is entitled to their compensation if you acquire a property during the representation period, even if they were not directly involved in the transaction. This could happen if you find a property on your own or work with another broker. Essentially, under the exclusive agreement, your broker is still owed compensation regardless of how the property was acquired, even if another broker helps you purchase the property. This protects the realtor from disloyal clients. Buyer includes any related person or entity. This clause clarifies that buyer refers not only to you directly, but also to any person or entity acting on your behalf. For example, if a company or a trust connected to you purchase a property during the representation period, or if someone else acquires the property for your benefit, the broker is still entitled to compensation. This is to ensure that the broker is compensated even if the acquisition is made indirectly through another party connected to you. Let's get the definitions of what broker involvement means. The buyer physically entered and was shown the property by the broker. The broker showed the property to the buyer virtually, like in FaceTime or on a video. If the broker wrote an offer on your behalf. If the broker performed a market analysis related to the property or reviewed property-specific documents or disclosures with the buyer, or if a property was introduced to the buyer by the broker, or one for which the broker acted on the buyer's behalf. However, okay, now here's the caveat. Merely sending a buyer a list of properties shall not be deemed broker involvement without documentation, action on the part of the broker analyzing the property for the buyer specifically, or assisting the buyer in the potential acquisition of the property, or communicating with the seller or the seller's agent regarding the buyer's potential acquisition of the property. So basically, in a nutshell, what that says is if a realtor just sends you a list of homes, that's not enough to show broker involvement. Continuation of right to compensation. This reiterates what we already went over. Again, I am going to be reading bullet points, but I strongly recommend that you take your time to read this contract thoroughly. Okay, so timing of compensation upon completion of any resulting transaction and through escrow. So basically, when you sell the home, when escrow closes, that's when your realtor gets paid, and they get paid through escrow. The broker shall be entitled to compensation whether any escrow resulting from this agreement closes during or after the representation period. Okay, so number 2 and number 3, this one is also really important. If acquisition is prevented by default of buyer upon buyer's default, this means that if you, the buyer, fail to follow through with your obligations in the transaction, whether it's missing deadlines, not providing necessary documentation, or otherwise defaulting, the agreement is clear that compensation is still owed to the broker, your realtor. Essentially, even if the deal doesn't go through because of something you didn't do, your default, the broker is still entitled to receive payment for their services. Number 3, if acquisition is prevented by a party due to the transaction other than the buyer. In this scenario, if someone else like the seller or another involved party prevents the transaction from going through, but you as the buyer still manage to recover damages, obtain specific performance, meaning the court forces the sale to happen, then the broker may be entitled to compensation. For example, if you sue or settle with the other party, such as the seller, and recover damages, the broker would be entitled to half of the damages you recover, but not more than the original compensation amount specified in paragraph 2E1. If the seller prevents the sale, but you manage to recover the money through legal action, your broker would get paid a portion of that money as compensation for their efforts, but only after your legal expenses and other related costs have been deducted. For this section, payment through escrow, it explains how your broker, your realtor, will be compensated during the transaction, and it introduces the concept of using escrow as a neutral third party to handle the payment. Here's the breakdown. Irrevocably assigning compensation to broker. As the buyer, you are irrevocably assigning the broker's compensation, aka the agreed upon amount from the contract, from the funds that will be held in escrow. This means that once the funds are in escrow, a secure neutral account, and basically escrow is a secure neutral account used to hold money until all the conditions of a real estate transaction are met. The portion of that is due to the broker and will automatically go to them as specified in the agreement. You cannot reverse this decision once it's made. You as the buyer are agreeing to deposit any necessary funds into the escrow account to ensure that the broker gets paid according to the terms of this agreement. In other words, you are committing to making sure there's enough money in the escrow account to cover your broker's compensation. The broker can provide the escrow company with a copy of this agreement, which authorizes them to disperse the broker's compensation directly from the funds held in escrow when the transaction closes. This section ensures that your broker gets paid through the escrow process, so you don't have to worry about handling the payments separately. Accounting for payments to broker if broker also represents seller. This section refers to a situation where the broker, your realtor, is representing both you, the buyer, and the seller in the transaction. As you know, this is called dual agency. If your broker is also the listing agent for the seller, meaning the broker has a separate agreement to represent the seller in the same transaction, then they are earning compensation from both sides of the deal. In this case, you, the buyer, won't receive a credit for the compensation that the seller owes to the broker for representing the seller. Why this is important? In a dual agency situation, the broker is earning compensation from both the buyer and the seller for their work on both sides of the transaction. This clause ensures that even though the broker is getting paid by the seller, the buyer is still obligated to pay their portion as outlined in their agreement to the broker. It also clarifies the broker's earnings from representing the seller don't reduce or negate the buyer's responsibility to pay their own broker fees. 4G, payments received from others less than buyer compensation obligation. This section is about handling situations where the broker's compensation comes from someone other than the buyer, specifically the seller, and what happens if the seller doesn't fulfill their payment obligations. Okay, let's break down each part. G1. This means that when you, the buyer, make an offer on a property, you and your realtor should talk about whether it makes sense to include a condition in the offer that requires the seller to pay for the broker's compensation. In many cases, the seller might agree to cover some or all of the broker's fees, which would reduce or eliminate what you, the buyer, owe your realtor. Section G2. This part addresses what happens if the seller fails to pay the broker as agreed. So if the seller agreed on the contract to pay some or all of the broker's compensation, that's also the realtor's compensation. You'll notice I'll say both broker compensation, realtor's compensation. It's all the same thing, but they don't follow through. You as the buyer are agreeing to assign your rights to the broker. This means that the broker has the legal right to go after the seller for payment on your behalf. Essentially, the broker becomes a third-party beneficiary, meaning that they can pursue legal action or other recourse to collect the unpaid compensation that the seller owes the broker. Section H. Disclosure of payments to the broker. This means that if the broker receives any compensation from a party other than you, the buyer, such as the seller, a third party, or any other source, they are required to disclose that information to you. Again, full transparency. This disclosure can be done directly by the broker or through the escrow process, where all financial details of the transaction are handled. This clause ensures that there are no hidden fees or payments being made to the broker without your knowledge. Cancellation of buyer representation agreement. This section explains how and when either the buyer or the realtor can cancel the agreement and what happens in terms of compensation if the agreement is canceled. Okay, let's break down section A. This means that both you, the buyer, and the broker have the right to cancel the agreement at any time by providing a written notice to the other party. The timing of this cancellation must comply with the specific period mentioned in paragraph 2F, which outlines the representation period. Both parties must follow the timing rules for how and when they can cancel. Section B, even if the agreement is canceled, the broker may still be entitled to compensation in certain circumstances. And once again, this is going to be a reiteration. If you, the buyer, acquire a property that the broker was involved in during the representation period or the continuation period, the broker must give you a written list of all properties, and the list of properties, here's something that we haven't talked about. The list of properties must be delivered to you within 5 calendar days after the effective cancellation date of the agreement. If they don't provide this list, then they lose the right to claim compensation for those properties. Let me bring up that form for you so that you know what that looks like. Okay, this is it. The Notice of Broker Involved Properties C.A.R form NBIP. This is it. This is what it looks like. And this is the section where they would list those properties. Section C, as the buyer, if you work with another broker after canceling this agreement, you are advised to inform the new broker that your previous broker may still have rights to compensation for certain properties. This is important because the new broker needs to be aware of any potential claims from the original broker, especially if you end up purchasing a property that the original broker was involved with. Okay, section 6, we're moving along. All right, so agency relationships A and B. A, the disclosure. Buyer acknowledges receipt of the disclosure regarding real estate agency relationships. This is one that we went over in the very beginning, in the very first document we went over. The second one we have not went over, so I'm going to show you that form and go over that one as well with you. It's the C.A.R form, PRBS form. All right, here we go. Possible representation of more than one buyer or seller, disclosure and consent. C.A.R form PRBS. This disclosure informs buyers and sellers about the broker's ability to represent multiple clients at the same time, including both buyers and sellers, and what that means for them. All right, let's break it down. Multiple buyers. The broker may represent multiple buyers simultaneously, meaning the broker might be helping several clients, including you, who are interested in buying properties. Some of these buyers might be interested in the same properties, and the broker is not required to limit or restrict any buyer from making an offer on a particular property. Even if the broker is helping other buyers to make offers on the same property you're interested in, they must treat each buyer fairly and not favor one over the other. Multiple sellers. Just as a broker can represent multiple buyers, they can also have multiple clients with listed properties. Some of these listed properties may appeal to the same buyers, and the broker will market all of the properties to the potential buyers, whether or not those buyers are represented by the broker. The broker may have several properties for sale at the same time, and some buyers may be interested in multiple properties listed by the broker. The broker will continue to market all properties equally to all potential buyers. Dual agency. So dual agency, you already know what dual agency is. It's when the broker represents both the buyer and the seller in the same transaction. The broker as a dual agent cannot disclose confidential information about either party, buyer or seller, without their permission. This includes financial details, motivations, or bargaining positions. And in dual agencies, the broker is still required to disclose any known facts that materially affect the value or desirability of the property, such as major defects or issues, to both parties. Okay, so this one is a really good one to pay attention to. Offers not necessarily confidential. Okay. So buyers should be aware that offers are not automatically confidential unless there is a signed written agreement by all parties agreeing to confidentiality. By all parties, keywords. Let me show you what that form looks like. This is the form right here, confidentiality and non-disclosure agreement, CAR form CND. Kind of reminds me of a NDA, right? When celebrities sign something like this, all parties have to agree. So look at right here, seller or buyer's name, and you select what you want to be confidential. Do you want the offering price for the property to be confidential? Do you want the offered terms for the property to be confidential? What else? Is there anything else from the offer that you want to be confidential? Everybody has to agree to this. Okay, let's go back to the other form. Without that confidentiality agreement signed, this means that the seller or the listing agent can potentially share the details of your offer with other parties or potential buyers. The decision to disclose offer details can depend on factors like current market conditions, the listing agent's strategy, or the seller's instructions. By signing this form, both parties consent to the brokers representing multiple clients, including potentially both the buyer and the seller in the same transaction. Properties excluded from representation. Okay, remember there was a section there. Let me go back to it really quick to show you, to refresh your memory. Properties excluded from representation right here. So this page serves as the summary of the contract and everything that's agreed to. And then this is the explanation and the summary of everything that is mentioned here. Okay, so let's dive into what that means. So this section addresses the potential for conflicts when a buyer works with more than one broker, non-exclusive agency, and outlines how properties shown or handled by other brokers are managed in relation to the current broker agreement. So here's the breakdown of each part. Section A, advisory regarding buyer signing multiple buyer representation agreements. If you, the buyer, have signed other buyer representation agreements with any other broker for any property, whether exclusive or non-exclusive, you must inform your current broker in writing. This ensures transparency and avoids potential conflicts between brokers. Section 2. If another broker has shown you a property, either virtually or in person, written an offer on your behalf, or acted for you in any way regarding that property, you must disclose this information to your current broker. If you purchase a property that another broker was involved with, you might owe that broker compensation. Section 3. If you signed an exclusive buyer representation agreement with another broker and it hasn't expired or terminated, you may owe compensation to that broker if you buy a property, even if the other broker had no involvement with that specific property. Section 4. In paragraph 2D of the agreement, you must list any properties where you are obligated to pay compensation to another broker. This ensures clarity regarding which properties might cause conflict. All right, section 7B, conflicts with other broker. This section ensures that the current broker has clarity about any conflicts that could arise from your relationships with other brokers. You are confirming that for any property identified in paragraph 2B, you do not have an active exclusive representation agreement with another broker. Unless specified otherwise, you confirm that you have no obligation to pay another broker under a non-exclusive agreement for the properties listed in paragraph 2B. This confirms that the current broker should be the only one entitled to compensation for those properties. Section 7C, limitation on broker representation. This section limits the current broker's responsibility to help with properties where you're obligated to pay another broker. If you have a prior obligation to compensate another broker for any specific property listed in paragraph 2D, the current broker is not required to help you with that property. In other words, the current broker won't be involved in any property where you owe compensation to another broker, and you won't owe the current broker any compensation for those properties either. Broker authorizations and obligations. This section outlines the duties and responsibilities that the realtor agrees to fulfill when representing the buyer in a real estate transaction. It also establishes certain limitations and clarifications regarding the realtor's role. Here's the detailed breakdown. Section 8 A. The broker/realtor commits to using reasonable effort and exercising due diligence in helping you achieve the goals outlined in the buyer representation agreement. This means that the broker will actively work on your behalf to assist in the home buying process, but there are limitations to what they can control. This section specifies the various ways in which the broker will assist you as a buyer during the transaction. Number 1, locating properties and presenting offers. The broker will help you by finding and presenting properties that meet your criteria. The broker will also present offers you've authorized, assist with negotiating the terms and conditions of the offers, and facilitate the process once an offer is accepted, including the escrow process. Number 2, ordering reports and scheduling appointments. As directed by you or as agreed upon with you, the realtor will help by ordering reports such as inspections or appraisals, and by scheduling and attending meetings or appointments with other professionals like home inspectors or contractors that you choose. Number 3, providing a list of professionals. If you request it, the broker can provide a list of professionals who can perform services that are outlined in the buyer's investigation advisory, and that's a form that we're also going to be going over. The realtor is only required to provide this list if they have a referral for the services you are requesting. Number 4, assisting with financing. The broker can assist with the financing process by making referrals to lenders they know or by helping you obtain a loan pre-approval. However, the broker may not act as a mortgage loan broker unless they are licensed to do so, meaning they won't be directly involved in obtaining the loan itself, but will guide you in connecting you with lenders. 8C, if the property in question is a residential property with 1 to 4 dwelling units, the broker is required to conduct a visual inspection of the accessible areas of the property. This excludes common areas if it's a part of a multi-unit property. The broker will disclose to you any facts affecting the value or desirability of the property that are revealed during the visual inspection. However, this inspection is limited to visible areas and is not as thorough as a professional home inspection. 8D, delivery of disclosures and information. The broker is required to deliver any disclosures, materials, or information they receive or personally know during the representation period. For example, if the broker learns important facts about the property, they are obligated to share that information with you. The broker is not responsible for verifying the accuracy of the information they provide unless this is specifically agreed upon in writing. This means that while the broker will pass along relevant information, they cannot guarantee its accuracy. 8E, compliance with anti-discrimination laws. The broker's services are conducted in full compliance with anti-discrimination laws, ensuring that their actions and representation of you are fair and non-discriminatory. This includes adherence to laws such as the Fair Housing Act, which prohibits discrimination based on race, color, religion, sex, national origin, disability, or familial status. Buyer obligations. In this section, it outlines the key responsibilities you as the buyer agree to fulfilling working with your realtor under the representation agreement. Here's an in-depth breakdown of each point. 9A, good faith. As the buyer, you agree to timely review and consider properties that the broker presents to you, negotiate in good faith when making offers and attempting to acquire a property, continue to act in good faith in completing any contract for the purchase of a property. In short, you're committing to cooperating with your realtor and making a genuine effort to purchase a property. B, financial and personal information. This section ensures the broker has the necessary information to confirm your ability to buy a property. Number 1, providing financial information within the time frame specified in paragraph paragraph 2G1, you must provide your personal and financial information to the realtor, which includes your proof of funds and your pre-approval or pre-qualification letter from a lender to show that you're financially able to acquire a property. If you fail to provide this information or you don't get pre-approved for your loan, the broker, realtor, can cancel this agreement in writing. Number 2, including a term for the seller to pay the broker. If certain boxes are checked in paragraph 2G2, A, you agree to include a clause in your offer asking the seller to pay your broker's compensation. B, this agreement is contingent upon the seller or others agreeing to pay the broker's full compensation. If the seller doesn't agree to cover the broker's compensation, the broker has the right to cancel the agreement for that specific property. If the broker cancels, they will notify you, the seller, and the listing agent that you are proceeding without representation, and a new agency confirmation will be completed, removing the broker from representing you for that specific property. The reasonable care and other professional assistance. Number 1, you are responsible for reading all documents related to the transaction. Number 2, you agree to seek help from appropriate professionals such as inspectors, attorneys, CPAs, or tax consultants, contractors, etc., especially those listed in the buyer's investigation advisory. Number 3, you are advised to read the attached buyer's investigation advisory, which includes a list of items that may require further investigation or inspection. D, reports and investigations. You agree to cover the cost of any reports, investigations, or meetings arranged by the broker on your behalf, such as property inspections or appraisals and things like that. E, buyer material issues. If there are any material issues related to the property, such as a specific property condition or information that you are seeking, you must inform your realtor in writing. If you fail to disclose these material concerns, the property will be considered to have met your needs and your preferences as they were outlined if you completed a Form BIPP. If you provide incorrect or incomplete information or fail to disclose material concerns about the property in writing, you agree to protect the broker from any legal disputes or claims that arise as a result. This also includes covering the legal costs. In this section, it outlines who's responsible for legal costs in case of a dispute arises between you, the buyer, and the realtor that arises from this buyer representation agreement. If a legal dispute occurs between you and the realtor, whether it's a lawsuit, legal proceeding, or arbitration, each party is responsible for paying their own attorney fees and legal costs. There may be exceptions to this rule as outlined in paragraph 12A. If there's a specific situation covered under that paragraph, different rules regarding attorney's fees might apply. Section 11, management approval. If a salesperson or broker associate signs the agreement on behalf of the broker or manager retains the right to review the agreement. The broker or manager can cancel the agreement in writing within 5 days after the agreement is signed if they choose to do so. Section 12, dispute resolution. This section outlines how disputes between buyer and the broker should be handled, emphasizing the use of mediation before resorting to legal action or arbitration. It also lists specific exceptions where mediation is not required. Here's the breakdown. A, mediation. If a dispute arises between the buyer and the broker, both parties agree to attempt to resolve the issue through mediation before taking the matter to court or arbitration. The cost of mediation, if any, will be equally divided between the parties. If a party begins a lawsuit or legal action without first attempting to mediate, or if a party refuses to mediate when requested and the party loses the case, the prevailing party, the one who wins, is entitled to recover their attorney's fees from the party who refused mediation. This provision overrides the rule in paragraph 10 where where each party is responsible for their own attorney's fees. If someone skips or refuses mediation, they could end up paying the other party's legal costs if they lose. 12B, additional mediation terms. Certain matters are excluded from mediation, meaning they do not require mediation and can go straight to legal action or arbitration. These exclusions are: 1, judicial or non-judicial foreclosure. Actions relating to foreclosures on properties or other proceedings to enforce a deed of trust, mortgage, or installment land sale contract do not need to go through mediation. 2, unlawful detainer action. Disputes related to evictions or unlawful detainer actions when a tenant stays in the property without legal right are excluded from mediation. 3, mechanics lien. Issues related to the filing or enforcement of a mechanics lien, a lien filed by contractors or suppliers for unpaid work that they did on a property, those do not require mediation. If a party needs to file a court action for an urgent matter, like a notice of pending action, attachment, receivership, or injunction, they can do so without waiving the mediation requirement. However, they must request that the court put the litigation on hold while mediation process takes place. Section 13, legally authorized signer. This section defines the responsibilities and requirements when a person is signing the agreement on behalf of a legal entity, such as a trust. When the legally authorized signer signs the agreement, they are doing so in their capacity as a representative of that entity, not as an individual. Their signature represents the entity they are signing for, unless otherwise stated. The signer confirms that the entity they are representing is legally established and in good standing to do business in California. This means that the entity is compliant with state regulations and is officially recognized to conduct business. 3 days of signing the agreement, the legally authorized signer must provide documentation proving that they have the legal authority to act on behalf of the entity that they represent. The document mentions several types of evidence that can be used to prove the signer's authority. They are certification of trust for properties that are held in a trust, letters testamentary for executors of estates, court orders if required by law, power of attorney if someone is signing on behalf of another individual, corporate resolutions if a corporation is the buyer or the seller, formation documents of the business entity such as articles of incorporation or LLC formation papers. Section 14, entire agreement. This section sets forth that this document represents the complete and final agreement between buyer and the broker, and no prior agreements or oral conversations can contradict what's written here. Here's a quick breakdown. All agreements, discussions, or understandings between you, the buyer, and the realtor related to this transaction are included in this written document. Nothing outside of this agreement is legally binding unless it's in the document itself. The agreement is considered the final and complete statement of all terms agreed upon by both parties. It fully encompasses all of the elements of the deal and is the exclusive source for understanding what both parties have agreed to. No previous agreements or oral conversations can be used to contradict or change the terms of this written agreement. What's in this agreement takes precedence, and anything that was said or agreed upon before this document was signed is not valid unless it's included in the written agreement. Any changes to the agreement must be made in writing, and it must be signed by both parties, both the buyer and the realtor, for them to be valid. This ensures that any amendments to the terms of the agreement are clear, documented, and mutually agreed upon. If any part of the agreement is found to be invalid or unenforceable, for example, by a court, the rest of the agreement will remain in effect. This ensures that a single invalid provision doesn't void the entire contract. This agreement can be signed in counterparts, meaning each party can sign separate copies and together it will form a valid agreement. Additionally, electronic signatures, copies, and scanned versions of the agreement via email or fax are considered valid forms of execution. Section 15, exclusive representation. This section outlines the terms that apply if the representation agreement between the buyer and the broker is exclusive. If the exclusive option is checked and the buyer initials it, the following conditions will apply. 15A, exclusive agreement. The broker is committing their time and resources to help you, the buyer, find and acquire a property with the expectation that they will be compensated for their services. You, as the buyer, agree not to enter into another representation agreement that conflicts with this one during the representation period. This means you cannot work with another broker for the same purpose while this exclusive agreement is in place. B, compensation. The broker is entitled to their compensation if you purchase a property during the representation period, regardless of whether the broker had direct involvement in helping you acquire the property. Another broker is also involved and is being paid for representing you. This means that even if you find and purchase a property without the help of your realtor, or if you work with another realtor, the original broker, the one that you're signing this contract with, is still entitled to compensation because of the exclusivity of this agreement. C, cancellation. Either you or the broker can cancel the agreement at any time by giving the other party 30 days written notice. If the agreement is canceled, the broker can still be entitled to compensation under certain conditions. If the broker provides you with a list of properties where they had involvement within 5 days of the cancellation, and if you purchase any of the properties on that list during the representation period or the continuation period, the broker will still be entitled to compensation. Section 16, confirmation of compensation. This confirms the compensation specified in paragraph 2E1 for the broker's services. It reiterates it again. And there's a box here to check if there's an attached compensation schedule that applies as well. This section here identifies if you're signing on behalf of an entity, and this is the signature section where you sign. Okay, up next is the Buyer's Investigation Advisory, CAR Form BIA. This is the one that we've been talking about. Let's dive into it. This section emphasizes the buyer's responsibility to thoroughly investigate the physical condition of the property and ensure that all aspects are checked before completing the purchase. Neither the seller nor the broker guarantee the physical condition of the property, including the land and any improvements such as buildings or structures on it. This means that it's up to the buyer to investigate and verify the property's condition. As the buyer, you are responsible for reasonable care to protect yourself throughout the transaction. This includes investigating and understanding any disclosed facts, such as property defects or legal issues, verifying any information you're given about the property, paying attention to details that are obvious or that you should notice with careful observation. A general inspection, usually conducted by a home inspector, may not cover every aspect of the property. That can include issues affecting the property that are not physically present on the land, such as zoning, environmental hazards, or neighboring properties, and also potential hidden problems that might require further specialized investigation. If any professionals, such as a home inspector or pest control operator, recommend additional investigations, for example, if there are areas in the property that are inaccessible or need specialized attention, you should follow up and contact qualified experts to perform those investigations. Section 2, broker obligations. The broker's knowledge is limited to certain aspects of real estate transactions, and they are not qualified to provide advice on various specialized areas that may arise during the process of buying or selling property. For example, brokers typically do not have expertise to give advice on legal matters, environmental hazards, structural integrity, pest control infestations, tax, financial advice, If the broker provides you with referrals to specialists, the broker does so to help you connect with professionals who have expertise in those areas. However, the broker does not guarantee the quality or performance of those professionals. It is still up to you, the buyer, to ensure that the professionals that you hire are qualified and perform their work to your satisfaction. Section 3. In this section, you are strongly advised to investigate the condition and suitability of all aspects of the property. It is so important to thoroughly investigate various aspects of the property before purchasing it. We're going to go over the several key areas that you as the buyer are advised to carefully examine. If you choose not to investigate, you are acting against the broker's advice. Let's break down each aspect. A. General condition of the property, its systems and components. This section advises you to inspect all major systems and components of the property. B. Square footage, age, and boundaries. You should verify the square footage and dimensions of the property. Lot boundaries, fences, or other markers may not reflect the true property boundaries. These measurements are approximations and cannot be guaranteed by the seller and the broker. C. Wood destroying pests. Inspect the property for termites or other pests that could damage the structure. If conditions are conducive to an investigation, further investigation is needed. D. Soil stability. Check for potential soil issues, including settlement or movement of the property. Drainage concerns that could affect stability. E. Water and utilities, well systems and components. Investigate the availability and condition of water and utility services. For properties with well systems, check water quality, condition, and performance. Check the condition and adequacy of the sewer or septic system. F. Environmental hazards. Inspect for potential environmental hazards, including asbestos, lead-based paint, radon, or mold, contaminated soil or water, other hazardous materials or substances. G. Earthquakes and flooding. Determine the property's risk of earthquake or flooding, especially if it's located in a high-risk area. Fire hazard and other insurance. Research insurance options early in the process. Claims history or being in a hazard zone like wildfires, seismic, or flood zones may affect insurance availability and cost. I. Building permits, zoning, governmental requirements, and address. Check the zoning and government regulations to ensure the property complies with local rules and supports your intended use of the property. J. Rental property restrictions. Investigate any rental restrictions if you intend to use the property as a rental. These can include rent control, limits on the number of tenants, termination rights for landlords, Airbnb restrictions. K. Security and safety. Ensure the property complies with security and safety regulations, including pool and hot tub safety features, fire safety measures, locks and security systems. L. Neighborhood, area, subdivision conditions, personal factors. This section encourages you as the buyer to investigate and consider factors related to the neighborhood, area, and subdivision where the property is located. There's various external factors and local conditions that might influence your experience living in or owning the property. You are advised to investigate the following: the quality and proximity of schools and the presence of law enforcement services in the area, crime statistics and registered offenders, information about crime rates and any registered felons or sex offenders living nearby, availability of fire protection and other government services, including waste management or emergency services, the availability, adequacy, and cost of internet connections or other technology services like cable or fiber optics. Investigate any business or agricultural activities in the area that could impact the property, like noise, odor, traffic. Be aware of existing or proposed transportation projects, construction, or development that might affect noise, views, or traffic. Consider airport noise or odors from nearby industrial industrial or agricultural activities or any other sources that could affect your comfort. Investigate the presence of wild or domestic animals or potential hazards in the area. Investigate whether the area is home to protected species, wetlands, or botanical diseases that may affect future property development or maintenance. Check whether the property or neighborhood includes any historic or government-protected sites that may impose restrictions on property use or renovations. If the property is part of a subdivision with shared spaces, investigate the condition of common areas and compliance with governing documents or homeowners association rules. Consider the proximity to cemeteries, large facilities like hospitals, and how these might influence the environment. You are encouraged to consider how neighborhood influences may affect your cultural or religious preferences, as well as how well the area aligns with your personal needs, requirements, and preferences. By signing this below, the buyers acknowledge that they read, understand, accept, and have received a copy of this advisory. Broker Compensation Advisory, CAR Form BCA. Section 1 outlines the important information regarding the payment of the seller's broker when a property is listed for sale, the nature of compensation, and the potential for dual agency in a real estate transaction. 1A, listing agreement compensation is fully negotiable. When a seller enters into a listing agreement with a broker, they agree to pay the broker for their services if the property sells and escrow closes. The amount of compensation paid to the broker is fully negotiable and can vary based on factors like the broker's expertise, experience, and services that they will provide. It is important for the seller to negotiate these terms when entering into a listing agreement, as compensation is not predetermined or regulated by law. B, optional additional compensation if buyer is unrepresented. If the buyer is not represented by a broker, the seller's broker may have to take on additional responsibilities to facilitate the transaction. In such cases, the listing agreement may include optional additional compensation for the seller's broker due to the extra work. If the buyer does not have a broker, the seller's broker should use a buyer non-agency agreement, CAR Form BNA, to clearly state that they are representing only the seller and not the buyer. This prevents the seller's broker from being considered a dual agent in the transaction. B, broker may represent both buyer and seller dual agency. Dual agency is legal in California, meaning the same brokerage and sometimes even the same agent can represent both the seller and the buyer in a real estate transaction. In cases where the brokerage represents both the seller and the buyer, the broker is allowed to receive compensation from both parties, provided that both seller and buyer are informed of the dual agency relationship and are aware of the total compensation the broker will receive from each side. Section 2, broker agreements with buyers. 2A, buyer representation compensation is fully negotiable. When a buyer enters into a representation agreement with a broker, they authorize the broker to help them find properties to purchase. The buyer agrees to pay the broker for their services if a transaction is completed. The compensation the buyer agrees to pay the broker is not set by law and is fully negotiable. This allows the buyer and the broker to discuss and agree on the terms based on various factors, such as the broker's expertise and experience, the types of services the broker will provide, the broker's time and expenses during the process. 2B, requirement for written agreements. According to a national class action settlement involving the National Association of Realtors, NAR, brokers must have a written agreement with the buyer before showing them a residential property or giving a tour. This ensures that the relationship and compensation terms between the buyer and the broker are clear from the beginning. The agreement must clearly specify the amount of compensation the buyer is agreeing to pay the broker for their services. The broker cannot receive any compensation above the amount listed in the agreement, ensuring transparency. Starting in 2025, California law is expected to require that all real estate licensees, not just those participating in the multiple listing services, must have a written agreement with the buyer before showing them any type of property. Advantages of written agreements. Having a written agreement benefits both buyer and the brokerage, because it establishes clear expectations for both parties, clearly outlines the duties of the broker and the buyer, helps prevent misunderstandings over what is expected during the process, clarifies the amount of compensation the buyer's agent is to be paid, which helps avoid any disputes over payment. Section 3. When enlisting a real estate broker to represent them, buyers agree to pay the buyer's broker when escrow closes, but the person responsible for payment may be negotiated in the transaction. This section outlines the payment options for the buyer's broker when representing a buyer in a real estate transaction. It explains how the responsibility for paying the buyer's broker can be negotiated between the buyer and the seller with several different options. Here's the breakdown. 3A, buyer pays the compensation pursuant to a buyer representation agreement. The buyer and the broker can negotiate the compensation amount, which is then documented in a formal buyer representation agreement. This agreement obligates the buyer to pay the broker for their services. Once this agreement is in place, the buyer is contractually required to provide the agreed upon compensation to the broker by submitting the necessary funds to escrow before the transaction closes. 3B, seller pays the compensation. In some cases, the buyer's broker's compensation can be paid by the seller instead of the buyer. There are two primary methods for this arrangement. Number 1, buyer negotiates for the seller to compensate buyer's broker. The buyer can include a clause in their purchase offer asking the seller to pay the buyer's broker's compensation. This is a conditional offer, meaning the seller can either accept the request, reject it, or negotiate the term through a counteroffer. The possibility of asking the seller to pay the buyer's contractual compensation obligation should be discussed when creating a buyer representation agreement and prior to an offer being made. B2, buyer's agent negotiates an agreement directly with the seller. If the seller does not have a broker or is unrepresented, the buyer's broker can negotiate directly with the seller using a single party compensation agreement, CAR Form SP, requesting that the seller pay the buyer's broker's compensation. In this case, the seller would pay for the buyer's broker's compensation without forming an agency relationship with that broker. The buyer's broker would continue representing the buyer only. To ensure transparency, the buyer's broker should use a seller non-agency agreement, CAR Form SNA, to notify the seller that the broker is acting solely on behalf of the buyer and not as the seller's agent. B, changing practice related to a seller's broker's offer of compensation. In the past, a seller's broker could offer compensation to a buyer's broker through the multiple listing service, the MLS, which would facilitate the transaction. However, due to the recent National Association of Realtors NAR settlement, the seller's broker is no longer allowed to use the MLS to make these unilateral offers of compensation. As a result, the California Association of Realtors, CAR, listing forms no longer include these offers of cooperating broker compensation. Brokers must now negotiate compensation directly with buyers or sellers. This means that the buyers and sellers must negotiate compensation directly with their brokers without relying on the MLS to facilitate these arrangements. By signing below, seller and buyer confirm and acknowledge their understanding of the terms outlined in the broker compensation advisory. They are aware of the various options regarding broker compensation. Again, this section is really important. It emphasizes your responsibility to thoroughly inspect and verify all critical aspects of the property before purchasing it. By following the broker's advice to investigate, you minimize potential surprises or issues after the sale. And by the way, this whole written agreement is 13 pages. Okay, so let's go to the next page. Possible representation of more than one buyer or seller disclosure and consent. We already went through this one. The next one is the California Consumer Privacy Act Advisory, Disclosure and Notice, CAR Form CCPA. So here's a quick overview of this disclosure. It explains the California Consumer Privacy Act and how it applies to personal information collected during real estate transactions. It informs California residents about their rights under the law regarding how their personal information, PI, is used, shared, and protected. What is the CCPA? The CCPA grants California residents certain rights over their private and personal information collected by companies they do business with. Private information includes any non-public information that could be linked to you, such as photographs of your property, sales information about your property. During the buying and selling process, your personal information will likely be collected and shared with real estate agents and brokers, the multiple listing service, the MLS, real estate websites, service providers, lenders, title companies, and escrow companies. This sharing is part of the transaction process and allows for a smooth facilitation of the sale or of the purchase. If the company collecting your private information is subject to the CCPA, you have several rights. Your rights include the right to know what personal information is collected and whether it has been sold, shared, and with whom. Your right to request deletion or correction. You can request that businesses correct or delete your personal information. The right to opt out. You can stop the transfer of your personal information to third parties. Right to limit use of sensitive information. You can restrict how certain sensitive personal information is used. You may receive multiple CCPA notices from different businesses involved in your real estate transaction. Not all businesses are required to comply with CCPA. Some businesses still might maintain your personal information for legal or operational reasons. For example, brokers and MLSs are required by California law to maintain records for 3 years, even if you request deletion. To exercise your CCPA rights, where applicable, contact the relevant business directly. You can learn more about CCPA and your rights through the State of California Department of Justice and the California Privacy Protection Agency. By signing below, you acknowledge that you have received a copy of this California Consumer Privacy Act Advisory, Disclosure, and Notice.